thank you everyone for joining the call, and a really big thank you to Eve, who have been working with over many years now on helping us be effective with using our science to inform policymakers. And I'm really excited because Eve does a really amazing job talking about why doing the kinds of things that we do as scientists, which is writing papers and then writing things about them, and actually writing, is a really important part of the policy process in terms of making sure that legislation that Congress passes gets effectively implemented at the federal regulatory agencies. And I think what is really why we wanted Eve to talk with us today is she's going to talk about something that we do well, which is writing, and how we can make our science writing, turn it into a way that can be useful for integrating into the policy process through the public comment process. So Eve is a senior attorney in the Health Communities Program at Earth Justice. And people don't know, Earth Justice has the best tagline, which is "The Earth needs a good lawyer," and they're the best lawyer for the Earth and ourselves. They're the nation's largest nonprofit environmental law organization. She leads a team of professionals who work on protecting human health from toxic chemicals. So in her role at Earth Justice, they have worked with many and very different partners in legal settings. So community groups who are working on lead and suing EPA for stronger lead hazard, farm worker organizations who are improving protections from pesticide exposures. She worked on a successful petition with the Consumer Product Safety Commission to ban a toxic class of flame retardants and chemicals in consumer products. She's working with the Latino Union to sue EPA for failing to ban methylene chloride-based paint strippers, and we have been working with her on EPA's attempt to kind of remove science from different aspects of the updated Toxic Substances Control Act. So before Eve joined Earth Justice, she spent 15 years leading reproductive rights litigation for Planned Parenthood Federation. So she's definitely been on the front line of many important issues. So I'm going to turn it over to you, Eve. Thank you again for doing this. We really appreciate you taking the time to help us be more effective with our science.
Great. Thanks so much, Tracy and Joan. Thanks everyone for joining us today or joining us in the future on YouTube. As we all know, science is under attack in the Trump administration. And I know that many scientists and public health professionals are interested in knowing how they can use their expertise to stand up for science. So one of the ways that science is under attack is through rulemaking. This involves both rules that roll back health protective regulations, such as the proposal to roll back the Mercury and Air Toxic Standards Rule, the Clean Power Plan, and others, and new rules that are being proposed, such as what we call the Censoring Science Rule and what EPA refers to as the Strengthening Transparency Rule, which would require that scientists disclose all of their raw data, including confidential medical records, before the agency would consider a study's conclusions in its work. So I am going to talk today about how scientists and health professionals can use public comment periods on proposed rulemaking most effectively to fight these anti-science actions coming out of EPA and other agencies. And I also want to explain to you why it is so critical that you do this, why it's so critical that scientists and health professionals engage in these rulemakings and not assume that it's pointless and not assume that somebody else is going to do it. So before, in order to really understand this, I think it's important for everyone to understand what rules or regulations are and how they're adopted in the first place. So rules are, and again, rules are another word for regulations, are developed by administrative agencies like the Environmental Protection Agency or like the Food and Drug Administration to implement the duties that Congress gives them when it adopts laws, or also known as statutes. After Congress passes a law that directs an agency to do something, the agency will often adopt rules that fill in the gaps or flesh out the implementation processes. So for example, Tracy mentioned the updated Toxic Substances Control Act, or TSCA statute. In that law, Congress told EPA that it has to conduct risk evaluations of chemicals using best available science. But that wasn't self-effectuating. The agency had to adopt regulations that flesh out the process for how it's actually going to do that. So that's just one example of the kind of rules. But rules can really address the details of what the agency does and how it carries out its mission. So the first step in adopting a rule is the agency publishes what's called a notice of proposal, and that's published in the Federal Register, which is available online every single day. New proposals come out every single day. And the first part of that publication is called the preamble. It's a long, detailed explanation for what the agency is doing and why. And then there's the proposed text of the rule. Once the notice of proposed rulemaking is published, the public has an opportunity to submit comments. And with its comments, the public can submit data, information, studies, any kind of material that might be relevant to what the agency is proposing. And these submitted materials become part of what's known as the administrative record. Now, we'll talk more about the administrative record in a few minutes, because the administrative record is an integral part of any litigation challenging the agency's action. So again, everything that you submit becomes part of that record. Then the next step is the agency publishes a final rule. This final rule is considered a final agency action, and it can be challenged in court. So when the agency publishes the final rule, it has to explain why it's choosing this final action. And as part of that, it's legally required to respond to all of the substantive comments that are submitted. So if a scientist says, you've overlooked this air monitoring data showing XYZ, the agency has to respond to that and explain either why it's continuing to disregard that data or how it's incorporated that data into its final rule. So this is actually important, not just because it's a way of getting the agency to reconsider what it's doing, but at this point in the Trump administration, delay is our friend, and anything that we can prevent this administration from finalizing before it hopefully leaves office in January 2021, the better. And the more comments that are submitted, the more the agency has to respond to. And if it's truly a lot of comments, it can be quite onerous, and it really could slow down the process of adopting rules. As I said, we're going to talk more about the administrative record. So in a court action challenging any kind of rulemaking, the judicial review or the legal review of that rule is based entirely on the administrative record. There will be no trial in this kind of action. There will be no expert witnesses. All of the data that the court will consider will be from the record. So in some sense, submitting comments into the record is almost like being an expert witness in the kind of court proceeding that most people have in mind and think about. So legally, the administrative record consists of everything that the agency directly or indirectly considers in its finalizing the rules, including the comments that the public submits. One important point is that if you cite to studies in your comments, but you don't attach them, those studies are not technically part of the record. So it means that in litigation, if lawyers wanted to rely on that study, but it's not attached to the comments, it's just cited in the comments, it's very difficult for us to do that. So if you're citing to studies that you think are really important, have critical information that might be important later, please attach those studies to your comments, and we'll talk more about that towards the end. So that's let me just see. So I think one other point I wanted to make here is that when you're drafting your comments, don't think about, oh, I'm writing this to the Trump administration and they don't really care what I'm going to say. That's true, they don't. You're submitting your comment thinking of a future court, a future judge or panel of judges as your audience. So write your comments, and we'll talk more about this, but write your comments as if the audience is a very smart person, but who maybe doesn't really know that much about science. So don't think of it as you're submitting it to a technical agency that's fully aware of, toxicology or epidemiology. You're really trying to write it to a very smart lay person who doesn't have the background that you have. So, so moving forward to just give an overview of a little bit more of an overview of what this litigation, the ultimate litigation, is going to look like. So courts have the authority to strike down regulations on a couple of different grounds. First, they could find that the regulation is contrary to the statute. And in some way. So for example, many people are aware of the ongoing work to try to get EPA to ban the neurotoxic chemical chlorpyrifos. The statute that regulates the use of chlorpyrifos on food crops requires that EPA have a reasonable certainty of no harm, that the chemical will cause no harm in that use on food crops. So we would say, as lawyers, well, EPA can't possibly have this reasonable certainty of no harm because here are the scientific facts. And that's where you come in to lay out what those scientific facts are. Another kind of legal argument is the argument that the agency's action is arbitrary and capricious. So that's where the agency does something that's completely undermined by the facts. Like if EPA says chlorpyrifos is safe, and we say no, that's not so much a legal argument, but it's a factual argument. Here are all of the facts showing the ways that the evidence suggests that chlorpyrifos is very much not safe. And so therefore it's arbitrary and capricious for the EPA to ignore that data. So courts, as most people know, courts usually do give deference to agencies' expertise. So often courts will say, well, EPA is the agency that's charged with understanding environmental protections, understanding the impacts and the health effects of chemicals. But deference can absolutely be overcome by a strong factual showing that the agency is wrong. So again, don't be afraid to submit comments saying how the agency is wrong. So again, in terms of what's arbitrary and capricious, something is arbitrary and capricious if it's not well supported by the facts in the record. It's also arbitrary and capricious for an agency to fail to respond or to take into account well-reasoned and supported comments, either from professionals or from advisory committees. And one of the things that we've been focusing a lot in this administration is it's also arbitrary and capricious to change the approach to science without a reasoned explanation or without any new studies that support that change. So that's definitely important to point out if there is a change in approach that's not that's not supported by the science. So I'd like to move on to talk about, in more detail, more granularity, what should your comments look like if they're going to be effective? So the first point is, start out by explaining why the court should listen to you. Again, thinking about, almost this is a parallel process to appearing as an expert witness in court. What is your expertise? What is your background? What studies have you done? That's going to give a lot of weight to why the court should listen to you, and why maybe the agency doesn't get deference if you're saying it shouldn't get deference. Definitely make your comments as fact-based as possible, not just your opinion. Your opinion matters because you're an expert, but facts, overlooked data, data that was misconstrued or misapplied, give weight. Definitely, if you have information that the agency isn't relying on, especially if it's information about impacts on particular populations or particular communities, that's really critical to get into the record. And again, attach the data, attach the studies, because that's going to be that's what gets it into the administrative record. So I think it's worth talking a little bit about what's not effective in comments. Even though I think it's very hard now, because we're all feeling that there's a lot of outrage at what's happening. Just disagreeing with EPA on policy matters, just saying, this is going to harm communities, this is ignoring children. That's okay to start with, but you need to really, really back that up with the facts. You can't just say this is bad policy. You also shouldn't feel compelled to cover everything in your comments, especially if that means that you're going to get into it at a superficial level. If there's one thing that you are expert on, one thing that you really know about, comment on that, submit the data and the studies on that, and let other people who are experts in the other matters talk about those things. For one thing, it just makes it more possible that, we can't all do everything. It's important to engage where we have something meaningful to contribute. And then it also gives more credibility. You're not trying to cover everything. You're weighing in where your expertise applies, and that will make what you're saying more credible. So I just wanted to give some examples of what this has looked like in practice. And so on this slide, I've given, these are from comments that I'm familiar with from recent rulemakings, where two different approaches to how scientists have explained their expertise. The top one comes from somebody who's been in this field for decades and has published over 50 articles, intimately familiar with scientific literature. He lays that out in detail, and with a lot more detail than I've included here. The bottom example is a group of stream ecologists. They don't have that level of detail of publications, but they still explain what their expertise is. So either approach works, but it is important to say what it is that you're expert in, and to provide some basis for that. You can also, if you're submitting it just by yourself, you could submit your CV with your comments as just evidence of your expertise. So then, what should the comments themselves look like? And I'm just giving, this is just one tiny little section of comments that were submitted to EPA on the framework rules under TSCA, the rules that establish how EPA is going to go about conducting risk evaluations. And this was in the context of talking about the fact that EPA under this rule has to look at vulnerable populations in its risk evaluations, and has to take into account the particular vulnerabilities. And I'm just giving this as an example because I thought it did a good job of explaining this to a layperson, that there are intrinsic and acquired factors that determine the level of a population's susceptibility or vulnerability, and then actually talks about even subpopulations within that. Like in this instance, they're talking about children with Down syndrome, that they cite to studies. Hopefully they attach them as well. I can't remember if they did or not. But so that's just, they took the information and broke it into what seemed to me like manageable pieces. So that's just an example. Obviously, it can be done in different ways, but I thought that was, they did it well in this instance. I should actually add that this set of comments was submitted actually by law students who were, who their professor, it was a class on administrative law, and they were told to like use about courts to make decisions and write comments that would be useful, and I think they did a good job. Here's another example of comments that were submitted by an advocacy group, Cape Fear River Watch, also in the context of a TSCA risk evaluation of 1,4-dioxane. And I like this comment because this group has done their own studies, they've done their own monitoring, they've written some of their own reports on levels of 1,4-dioxane in the Cape Fear River, and they've attached their own monitoring. They've also collected monitoring that was done by others and attached that data. And they just laid out really clearly, like, so the middle paragraph states what EPA is saying, that the Safe Drinking Water Act is adequately protecting drinking water from 1,4-dioxane. So that's very clearly not true. And they go on to say this statement is false. And then they go on and back up why this statement is false. Again, attaching studies, attaching their own study and sampling results that they've done. So I thought this also, again, it's all going to be very context specific, but I thought this was a good example as well. So I want to just give you a couple tips for how, just technically, how do you submit comments into a docket? So most federal agencies accept comments through a website that's called regulations.gov. The comments are organized by the docket number. One small tip is that whatever the deadline is, comments are due at 11:59 Eastern time on that date. I was recently on the West Coast on the day that a set of comments were due with a colleague who was planning to submit comments, and she had it in her head that it would be 11:59 Pacific time, but no, and she missed the deadline. So keep that in mind. Also, I've been urging you to attach studies or attach materials to your comments, not just to cite to them. But one strong caveat is that agencies, and especially the Environmental Protection Agency, has been hesitant to publish on regulations.gov copyrighted material, such as studies that are published in journals. And so what we found is that if you have one PDF document that you're uploading and it includes both your comments and a published study, they may not, it still is in the record, it still exists, but they might not publish it for the public to see it. So we've tried to get around that by separately uploading our comments and exhibits to the comment. So they can publish our comments, our work for the public to see it, and then they won't upload the journal because of the copyright concerns, but they're still in the record that we can rely on in litigation in the future. So that might be something to try. Another thing just to keep in mind is that the maximum upload size is 10 megabytes. So if you're attaching a lot of data, a lot of studies, you may have to break it into separate uploads. But again, we do that all the time. It's not a reason not to do it. Just if you're waiting till the very last minute and you find that your file is too big, it can be frustrating. So the last thing I wanted to show you is some examples from court decisions of how comments are actually referenced. So this, all of these quotes here are from one particular case that that I was involved with. It was actually a challenge to a regulation that was adopted at the very end of the Bush administration, where they exempted industrial livestock facilities, or CAFOs, from having to report air releases. It's just a blanket exemption. And there were a lot of comments coming in from communities and from state officials, and actually rely on this data. Like when we learn about releases from these industrial livestock facilities, it's meaningful. So the first box on the upper left, this is from the court ruling, but they say that EPA requested comments on whether there might be a situation where a response would be triggered by notice of a release of these hazardous substances. And the court notes that none of the public comments changed the EPA's view. Well, that's what we expect in a hostile administration. Comments aren't going to change the agency's view. But then moving to the upper right, but the court looked at the comments, and the court said that they were helpful. The court noted that the commenters foresaw regulatory benefit to getting this notice. They put before the EPA a good deal of information suggesting scenarios where the reports could be quite helpful. So the court is looking to the comments. And then there was one specific, on the bottom left, one specific example where these state officials who are charged, it's the, I can't even remember what Sarah Title III, what that acronym means, but it's state officials that use these emergency notices. And they gave one example of how they might use these reports. So again, it's a very specific, concrete example, which is important. And then the bottom right, the court concluded that the comments undermine EPA's primary justification for the final rule, namely that this getting notice of releases serves no purpose. So this is a case that actually completely turned on comments that came in from the public, showing how the public notice requirements that EPA was proposing to eliminate, how that notice was actually really useful to communities and to local officials. So just, really hopefully in trying to inspire you that even if the agency isn't going to be swayed by your comments, courts in the future may be, and you really have so much to offer. I really strongly encourage you to get involved in this process. I guess maybe the final word is, after you've submitted strong comments, let people know about it. Tweet your comments, blog about your comments, send them to reporters, because again, we're really just trying to elevate for the public and get them aware of what's happening in Washington with this administration and how science is being undermined. So submitting comments is great. Letting the world know about them is doubly great. There's an organization that's based, I think it's out of the University of Washington, called publiccommentproject.org. It's not a very often updated site, but they do have templates that you could look at that might be helpful to you. If you wanted them, also just going on regulations.gov itself, you can see what other people are submitting. So that's a good tip as well. So that's it. I'm happy to answer any questions.
Oh, great.
Eve,
Can you hear
thank
me?
you so much. That was really, really great to hear. If anyone has any questions, please go ahead and type them in the chat box that's located. You can see a little icon at the bottom of your Zoom window that says chat, and you can just type those to the entire group. Marianthi and I are here, and I think we have a couple of questions to get us started. Marianthi, do you want to go first?
Yes, happy. I think, thank you so much for this. I think you've already answered. I was writing down questions and you were answering them as I was writing them, which means you did a great job. But I think I have a very naive and vague question for a foreigner coming in contact with the American system. Many of the things you said rely on EPA requested comments for this. So what if, or not EPA, in this case, EPA is the agency.
Yeah,
that,
sure.
But what if they don't? Is it possible? Is that even an option?
Well, if it's a regulation, if they're proposing a regulation, they have to submit comments. But it is, I mean, you actually raise a really important point, which is they can do things, they can issue guidance. Guidance doesn't have the weight of law, but it can actually, control what they're doing, and they can issue guidance without taking comments. And so that is a concern. And then, of course, you could still write letters telling them that this is wrong. And that might be an instance where actually blogging or tweeting might be especially important to say, look, EPA is all of a sudden changing course, adopting a new approach that's not based in science, and they're not even going through a public process. So we need to call them out or something like that. But that if it's a rule, they have to go through comments. But some of these other kinds of documents, like guidance documents, they can do without comments.
So we have a question from Anna Pollock, and she is asking, how do you recommend that scientists can be aware of deadlines that are coming up? Is there some sort of clearinghouse to follow that will let us know about relevant upcoming deadlines?
That is such a great question. And I think that so there are organizations that do this. Like I know the American Public Health Association often alerts its members to deadlines. You could look at the Federal Register every day to see what's happening. I personally do that. I don't think that's probably the best use of everyone's time, but I think this would be something that ISEE could do. I know that Tracy Woodruff's organization, and Tracy, feel free to chime in with on this, but the University of California, San Francisco program on reproductive health and the environment has a science response network, and they send to scientists that are on their part of their network about opportunities to weigh in. And I would urge people that are interested in this to sign up to be part of this network. And there may be other networks like that one that are alerting people to these opportunities. I know, Tracy, I don't know if you're still on.
Yeah, can you hear me?
Anything more about your network?
Can you hear me? Shoot. Oh, we can hear you. Okay, yeah, so we have a...
Tracy, if you come up with something great to add to that, let us know. So I'm curious.
Oh, she says she's talking. Oh. It's not working.
Yeah.
Go ahead.
Oh, everyone else can hear you, Tracy. We just can't.
Oh, you can?
Please
you just can't hear me. Okay, I will just say then. For those on the phone. Yeah, we have a science response network, which is the goal is to link up scientists who are interested being engaged in communicating their science to policymakers. So it can be anything from listening on webinars, but we do also send out notices about public comments and provide an opportunity to sign on to scientific public comments. Mostly it's been around TSCA, and I'll send out the link. And I'm done.
Cool, thank you. So just a logistical question. on kind of the types of comments that make the greatest impact. You showed us some examples, but I think for a lot of us, given how busy everyone is, like distilling this down to the most key pieces of information that we should include. So knowing that we need to attach things, that is really important for us to know. What else is particularly useful? So citing facts, if you could expand at all, do you think it varies so much?
I think it does really vary so much, but I think, attaching studies or data that the agents that is relevant, that the agency has overlooked, is really important. And if there's some fundamental flaw in the agency's analysis, so not just saying you did this wrong, but saying how it was done wrong and how it should be done and how doing it the correct way would lead to a different result. So, I mean, I guess, again, and I'm not an expert in the chlorpyrifos issue, but, if the agency is saying, focusing on cholinesterase inhibition and not focusing on IQ impacts. Mm-hmm. The idea to say that IQ is the most sensitive endpoint and you're not looking at that, and here's all the data showing that IQ is the most sensitive endpoint, and if you ran your numbers on that basis, mm-hmm. here's how it would come out. Any part of that would be really important information. Just focusing in on what they're doing wrong, and what would it look like to do it right.
Okay. Yeah, it sounds a little bit like doing a journal review where you need to find the fatal flaw, you need to come up with anything that's missing. So that's actually, that framework seems helpful.
Great. Yes, this is very helpful. But I was also thinking, though, again, going back to time and air pollution. I do a lot of air pollution work, and air pollution is it's a special case because of the ISAs that the agency needs to do, basically lit review,
yes,
as required by the Clean Air Act. So many of the papers that we would attach, we know that they already have.
Yes.
If they are, unless they're super, super recent. So then I think it's important to reattach, I guess.
No, if they have it, and especially if they, so usually in their, in the preamble, in their publication, if they cite to rules, if the agency, and they'll have a list of references in their publication. If they're referencing it, if they're saying they're relying on it, you don't need to reattach it. But say there's say the ISA is outdated and you're aware of a new study that maybe suggests something else that you would need to attach. Or if you're working with a community, if you're actually involved in a study where air monitoring is being conducted, for example. So this is, that kind of data would be incredibly valuable.
Okay. Thank you.
And I also like the idea of writing comments in a group. I think it can be pretty intimidating when you first start to think about putting just yourself out there. But I think if you can get together with a couple other colleagues and quickly work on some sort of Google Doc together, that could also be a helpful way of doing this.
Yeah, great idea.
Yeah, absolutely. And also, think here we are starting as ISEE North American chapter a policy committee that will hopefully be tasked to, and it is a group, and we will try to be we will be as involved as possible to be very reactive in a timely way to these deadlines coming up and drafting public comments. So this has been fantastic for that as well.
Great. Do you have any questions?
I have a very practical one. So assuming we have time to write comments and assuming we are experts in a couple of different issues, would it be best to break down and submit two separate comments, or it doesn't matter at all?
It really doesn't matter at all. But you could, like, if there's two separate issues, like say you might ask some of your members to sign on. So if different people would sign on to different things, it might be better to separate them out and give people comfort that they're signing on to something that they know about. One thing actually you're saying made me realize, so under the law that governs this whole process, which is called the Administrative Procedure Act, the agency has to give a minimum of 30 days to comment, but they often give more than 30. So 60 days would be common. Sometimes you get 90 days. And you also, it's often the case that people, especially on big monumental rules like the censoring science rule, people ask for additional time, and often those requests are granted. So if people feel like there's a very important proposal and you have really important things to contribute and you really can't do it in that time frame, there's no harm in requesting additional time.
Okay, so we can reach out to the agency. And
Yes.
it's to the agency or through?
It's to the agency,
Okay.
to the person that you submit the comments. Like all the comments have a contact person, and it's in that Federal Register notice. Reach out, contact person.
That's very good to know. Yes, thank you.
Okay.
Great.
All right. Well, thank you so much for being here, Eve. And we will be posting this on the ISEE Global YouTube channel in the next couple days. So if other folks missed it, they'll have access to it there.
Great. Thank you so much. I'm so happy that ISEE is doing this.
It's absolutely necessary to do this, I think. So thank you so much for coming.